Welcome back to our unit on the Constitution and how the Supreme Court protects the Constitution and interprets what it means. We're going to look today at the two different ways that judges, we call them justices on the Supreme Court level, explain their rulings, the decisions that they make when they hear a case. As we looked at in the last unit, when they interpret the Constitution, there are two major ways that the justices think about the Constitution. Some justices have a more strict interpretation. That means they read the Constitution word for word. If it's not written there in the document, it's not there. Justices who take a strict interpretation generally would say that there's no right to privacy, for example, because the word privacy doesn't show up anywhere in the Constitution. But justices with a more loose interpretation are more willing to say that the Constitution evolves over time. They're willing to read things into the document. So, for example, the Fourth Amendment protects our right against unreasonable search and seizure. The Ninth Amendment reserves to the people rights not stated in the Constitution. So some justices will look at that and say there is a right to privacy that is implied in the Constitution, and that privacy is therefore an implied power. So that's an example of the difference between strict and loose interpretations. Conservative justices tend to be more strict. Liberal justices tend to be more loose. The other thing, in addition to the Constitution, that justices think about when making a decision in a case is previous cases on the same topic. So, it's called case law, and rulings that the Supreme Court has made previously are called precedents. So if the Supreme Court is looking at a case that has to do with whether or not police can search somebody without getting a warrant, they would look at case law around Fourth Amendment cases to decide that question. The U.S. v. Jones case last year had to do with whether police in Baltimore could put a GPS device under a car without getting a search warrant. They said it was just like following somebody if an officer trailed somebody in an unmarked vehicle. Well, the court had to consider previous Fourth Amendment cases, and they ended up deciding that you do have to get a warrant if you're going to put a GPS under a car. That creates a new precedent. Now that that ruling has been made, police in Los Angeles know they can't put a GPS device out there without getting a warrant because the precedent was set in the U.S. v. Jones case that was decided in Baltimore. Now, when you actually look at the justices and how they come down with their decision, as you know, there are 9 different justices on the court. To get a majority opinion, which is going to create a precedent, you have to have at least 5 justices agree. They'll then write an opinion which explains the reasons for their decision. That's called a majority opinion. Justices that disagree, they often write what's called a dissenting opinion, which explains why they disagree. So, justices in the U.S. v. Jones case, the majority opinion wrote an explanation of why, based on the Fourth Amendment and the Ninth Amendment and other constitutional reasons, and case law, they felt that police could not do a GPS device without a warrant. Some justices thought that the GPS device was acceptable, and they wrote an explanation still using their own different interpretation of the Fourth Amendment and case law to explain why they thought you could use the GPS device without a warrant. So there's disagreement on the court. You and I might disagree with what the court ends up ruling in a case, but whatever the Supreme Court decides has to be enforced by the executive branch and respected by Congress. That's the way the Supreme Court works. We'll check back next time. Enjoy the video, and be ready for your quiz tomorrow.